Hello and welcome to Rock Your Block. I am your host and producer, Tia Young. Today, our returning special guest is the principal of the Haley firm, PC, in Washington, D.C. He is primarily a litigation attorney who focuses on individual clients rather than corporate interests. His practice includes probate of estates, wills, personal injury, and personal contract disputes. Please welcome Attorney Howard Haley to Rock Your Block. Welcome, Attorney Haley. How are you today?
I'm well. Thank you for having me.
Good, good. How was that drive coming in?
Traffic wasn't so bad.
Okay,
there were some issues, but otherwise it was okay.
Thank you. Okay, good. We're going to get right into it because we have a lot to go over in the next 30 minutes. So you are the principal of the Haley firm, PC. Tell us how long you've been in business and a little bit about your law firm.
Sure. I've been in practice since 2011. The Haley firm primarily focuses, as I said, on individuals. So, for example, grandma comes in, she's got a problem with a contractor. She tells the contractor, I need a new roof. Contractor says, great, we can do the roof for a dollar amount, whatever that number is. Grandmother pays the money or pays half the money up front. Contractor strips off the roof. And then, because grandma's now a captive client, says to her, well, we need another $5,000 to finish. The price has changed, materials have gone up, or things of that nature. Right. Well, if grandma calls our office, we get involved and we remind the contractor, you had an agreement for a certain amount to finish this job. If you misprice the job, that's still your responsibility to finish the job. And we hold the contractors accountable. If the contractor refuses to cooperate or chooses not to, we find another contractor to finish the job, and then we represent grandma against the first contractor for the monies that she had to pay at the end to the other contractor, because the first contractor should have done the job for what he promised.
Right. Do you have many people playing games with grandma, or?
There are many unscrupulous contractors out there, but there are many good contractors as well. Mm-hmm. I recommend to people all the time, if you're looking for a contractor, check out the contractor especially in the District of Columbia, with DCRA before you enter into an agreement. Because if the person's not properly licensed, or if they've got multiple complaints or a historical record of not doing the right thing, DCRA has a record of that.
DCRA?
Yes,
Is
ma'am.
that it? Okay.
Yes, that's the governing body that administers licensing and registration for contractors, electricians, cement, masonry experts, electrical persons, plumbing. Mm-hmm. They issue all the permits for every building construction that's done in the District of Columbia.
I didn't know that. Okay, good. Now, you are primarily a litigation attorney, but do you serve your clients in other areas as well?
Oh, yes, ma'am. We have come to be a practice where we assist folks with the drafting of wills. We do probate of estates when people have passed away. We help folks with a variety of issues that people come across. Sometimes clients will come to us and say, can you take a look at this lease? I'm not sure if it's good, it's bad, or if I need to look at what changes I need to make. Sometimes clients who own rental properties want us to look at the leases that they're providing to their clients. And so we go through some of the additional issues that they may have. But more often than not, we run into clients who are dealing with the death of a loved one, and they realize that, well, I don't have a will either, and grandma didn't have a will, but grandma has a house, but who owns grandma's house? And that creates a lot of problems in the probate side of the house, because, for example, we had a family where a husband and wife were married. They got divorced. The court divided the property, the house that they owned, as tenants in common without the right of survivorship. Well, when that happens, the person who owns one half, whether it be husband, wife, now in DC, a partner of some type, owned one half of the house, and the other spouse owned the other half of the house. When spouse A died, the spouse did not give the property to the other spouse. So he still owned that half. And he dies in 2005, mama dies in 2019. The family thought mom owned the house. Mom didn't, she only owned half. So because there were 11 children, and 3 of those children had also passed away, estates had to be opened for each one of those children who passed away and the spouses of those children who also had passed away. So 7 estates had to be opened to be able to get permission from the court to sell the house. Because in the District of Columbia, some estates fall under the old law and some estates fall under the new law. And under the old law, everything requires court approval. Under the new law, and which is determined by when the person died, the new law, you can get an unsupervised estate where the PR can make whatever decisions they need to make and move forward with the sale. But in this situation, half of the estate was under the old law and half of the estate was under the new law. So the new estate couldn't move forward without the old estate getting approval to move forward. And it created other conflicts. So these are things we go over with clients. Who owns the house you live in? Do you own the house? Is it owned by a relative? If it's owned by a relative, is it what you believe to be the ownership or is it the actual ownership? So we work with the recorder of deeds and pull the information and provide it to the client and help advise them about what they need to do to clear the title to make it easier for them to move forward.
So in a case like that, you said 7 different estates.
Yes.
Who pays for the work on that?
Well, each of the heirs for the 7 estates had to cover the fees. So the primary estate was the grandmother's estate that grandma lived in, but all the children were raised in that house. So because the father's half of the estate wasn't owned by the mom, each of the 11 heirs had to consent to the mother and father's estate, and then each of the heirs who were entitled to receive a share, if someone had passed away or their spouses had passed away, that's 2 estates that had to be open, and the heirs of those estates had to consent for them to be able to give consent for the heir of the first estate. So it can get complicated.
Yeah, so just because you marry somebody, that doesn't mean automatically that you own everything that they may own.
Yes, ma'am. There's specific, what we often refer to in legal business as magic language. For example, if your deed said husband and wife as joint tenants with right of survivorship, then that means when one of the spouses died, the other one gets the property. No questions asked, you just file a new piece of paper, one single piece of paper with the recorder of deeds, and the property now is all the other spouse. But if you don't have the language with right of survivorship, then this spouse still owns half and this spouse owns the other half.
Wow.
And when that person passed away, if you didn't probate it, the property still sits in that person's estate. And there have been mistakes where people have sold houses where the first person that owned the house thought that, well, I own it with my husband, I now own the house. And they went to the recorder of deeds and they've recorded the house, it's mine. And they put it in their name, but they never opened an estate. So they didn't have legal authority to sign for their husband. And because they didn't have the legal authority, it created what's called a cloud on title. So they sold the property. Person X now takes the property, they rebuild the property, they turn it into condos, they now want to sell it. Well, the underwriter won't insure the title because the father's estate was never gifted to the wife. He never gave it to her. So since he never gave it to her, she didn't have legal authority to put it in her name. There's an easy fix for that, but it requires the opening of an estate for the deceased spouse. That estate has to then convey to the other spouse, who's now also deceased, their portion of the estate. But because that conveyance, it automatically snaps back in time and fixes the previous problem.
Wow.
But that's a title problem that underwriters sometimes catch, and if they don't catch it and it moves on, then it creates a bigger problem down the road because you have to go all the way back to the first transaction to fix it.
Right. Well, Attorney Haley, our viewers are really, really smart, but I'm not. So I've got some questions. I need some terms.
Sure.
If you can help us out. Maybe there are a few people that might not know some of the answers here.
Sure.
The first is, what you've touched on it a little bit, but what is a litigation type of case? Is there more than one type of litigation case, or?
Yes, ma'am.
Okay.
But to put it in a nutshell, the cases, most often lawyers are in a category of either they're litigators or they're transactional. Litigation attorneys go to trial. They provide cases where there's an adversarial position, where there's a person on one side, either a plaintiff or defendant, for example, in a civil or a criminal case. And litigation usually falls in civil or criminal for the most part. Civil side of the house is what we're talking about with doing an estate, for example, which comes with civil penalties or fines and things of that nature where money can be awarded or judgments. Criminal penalties are cases where the freedom of an individual are subject to question that the court can then impose a restriction upon someone's freedom. So Most often litigation cases, many of the cases in the United States, especially civil litigation, roughly 80 to 90% of them are settled before going to trial.
Oh, okay.
And that's because the courts have a mandatory mediation requirement. More often than not in most jurisdictions, and especially in the District of Columbia, there's a mandatory mediation. Even at the Court of Appeals, there's another mediation level that's required. Because if the parties, clearer heads can actually separate the emotions and look at what the facts are, usually you can get to an agreement where you can resolve the problem. The problem is getting people to separate their emotions from the facts in order to make a decision.
That's a good point, separating the emotions from the facts.
It's a very difficult thing to do.
Yeah.
And one of the things that's one of the reasons why my firm I don't do any family law, because I get caught up in the emotional side of the house and I can't separate the emotions of, well, this is a family and no matter what happens in litigation, the family's still going to be a family, but can you overcome what's necessary to win? And it's too complicated for me, so I don't do family law for that reason.
What is covered in probate of estates?
Everything that belonged to an individual who passed away. So, for example, you take a 75-year-old male who's living in the District of Columbia. They worked for the city, they had a pension, or they had a retirement fund. Well, many people confuse whether retirement funds and pensions are a part of an estate. Typically, an individual designates a beneficiary, and that passes outside of the estate. But if they don't have a designated beneficiary, then it belongs to the estate, and the estate has to distribute the assets to the heirs. And if there's no will, then the per stirpes distribution is what happens. The court has a mandatory scheme of how these distributions are made, and there's a category of preference for creditors, bill collectors, asset managers, things of that nature, that have to be paid before the heirs can receive their money. There's a priority of distribution. And that's why in the District of Columbia, the first $15,000 or $25,000 of an estate generally is earmarked for the spouse or the children, and then the balance of the estate can be distributed because they don't want heirs to be left out in the cold because the creditor came in first. But outside of those designations, the distribution is done according to the statutes.
Okay. I know that wills cover a lot, but are there major wills that people should be concerned about? Are there 3 or 4 things that you definitely need to have?
Well, there are a lot of people that ask the question of, well, do I need a will? Is it something that I should have or not? And we remind folks all the time, you may not have all of the assets you're going to have at the end of life today, but today you have a wife and you have children, or you have a husband and you have children, or you don't have children, you have pets and you want to be able to pay someone to take care of your pet. Well, there are reasons to have a will even if you don't have accumulated a variety of assets. For example, you're 25 years old, your 80-year-old grandmother passes away and she gives you an heirloom brooch. That brooch may not be of any value to anyone else, but it's of value to you and your family. A will designates who you want to have that brooch, or where do you want it to go if you're passing it on. If you have children, you can designate them. If you don't, and you have nieces and nephews or another aunt that you may want to have it, then you can designate, I want this to go to that person. But without that, who knows what your wishes were? It's the only way to tell your family, this is what I want done with my things. For example, a record collection, for example. You never know what the value of a record collection may be. Comic book collection. Some people didn't realize that the first Superman comic book was worth millions, but it was sitting in the most recent one that was found was sitting in an attic. But the will said, all of the residual of my estate I give to X. And that person was cleaning out the attic and found the comic book. Well, because it wasn't designated in the rest of the estate to go to anyone else, it went to the person who was designated to receive the residual area of the estate. So that individual became a multimillionaire overnight, solely because of something that was in the attic that no one knew that it had any value, but he was the residuary holder of the estate. And there are a lot of estate sales where people find valuable assets that no one knew of or were not included in a will, but many people don't include what's called a residual clause in their wills. And without that, the asset has to be sold and then distributed amongst all the heirs and equal shares.
So I better go back through my comic books, my old comic books, and see what I have.
It would be a good idea.
So what is included in a personal injury case?
Personal injury cases are often, more often than not, they're automobile accident type cases.
Okay.
But there are often cases where a person slips and falls in a grocery store or on a private property, for example, or even on the sidewalk of the local municipality. But a lot of things that people don't realize is, well, the first thing you must do is document everything that's happened. Even if you can't, if you don't write well, get a tape recorder. Speak into a tape recorder, take your phone, put it on memo mode, and talk to it. If you don't have a memo mode on your phone, or if your phone is not old enough, then call yourself on your phone and leave a voicemail and say, this happened on this date at this time. That's a record that you can begin to create, because people don't realize the things they forget.
Right.
A lot of things will be happening at that time. For example, an ambulance is picking you up to take you to the hospital. You don't necessarily know who's standing around. Well, we recommend that folks, one of the things in one of the articles that I've written for some of the local publications is I recommend clients keep a disposable camera in your glove box. Because a disposable camera, you can take pictures of the accident scene at that moment. Right. And ensure that you get pictures of anybody you can find standing around, tag numbers, license plates, the street corner, street signs, because you want to see if there's a video camera in the field of frame. Right. Well, if there's a video that may have captured the accident, you may not remember that there was a video camera there, but that camera photograph you took will remember. And now with digital phones, and everybody's got phones on their pictures on their cell phones, especially the iPhone users, when they take the picture, it's uploaded to the cloud. If you've got an Android, sometimes you've got it back up with Google Photos or not. Sometimes you do, sometimes you don't. But if your phone gets damaged, you still have access to the photographs. And those photographs can help lead your attorney to witnesses who may have seen the accident. Even maybe the accident was your fault and not the other driver's fault. Right. Those are things that can help be resolved by speaking to the witnesses who saw the accident. Then, as well, who were the medical professionals who arrived on the scene? What steps did they take when they arrived? Once you've been treated or taken to the hospital or seen your primary doctor, if you don't go to an ambulance, see your primary doctor as soon as you can. They will refer you for necessary treatment, and they will then put in their notes that this is related to an injury sustained on such and such a date. Right. One of the things that people fail to do is, well, I'll be fine, and they go home. And then the next day, they're not fine. Right. But then instead of going to see their doctor, they say, well, I'll be okay. I'll take Tylenol, I'll be okay. But then when they finally see their doctor, the doctor says, well, no, you're not okay. This should have been seen a couple of weeks ago. Well, they think, well, I don't have a claim anymore. You still do. But you got to have your medical provider indicate this is a result of this and link the issues so that the issues can be tracked by the insurance agent. Insurance companies are often felt like people believe that their role is to deny. Well, part of their role is to deny. But their requirement is to pay claims that they're legally obligated to pay, not to pay claims just because someone made one. So oftentimes people get mad at the insurance company because they're saying no, but what they're really saying is, show us a linkage so that we can track down why this is a responsibility of our client. And that's all they do. I mean, it's the nature of the business itself.
Okay, well, we're going to go back a little bit to wills, but we're going to play a game.
Okay.
I'm going to say a word, and you're going to tell me how it would be addressed in a will.
Okay.
But you have to do it within a few seconds.
Okay.
Okay, let's see how you do. Kids.
Heirs.
Houses.
Distribution.
Spousal situations.
If you're married or divorced, that takes consideration, but you still follow the ordinance of the court orders.
401k.
Make sure you designate a beneficiary.
Insurance.
If you don't have it, get it. And if you do have it, make sure it's up to date with which beneficiary you want to have what.
Okay, very good. You won. And I'll tell you your prize later, okay?
Thank you, ma'am.
Okay, the other thing that touched me when you were speaking earlier is that question, do I need a will? My question to you is, why is it so many people, and I think this goes across cultural and racial barriers, why do people always feel that they have time?
Well,
Young people feel they have time, and even older people. I've met people 50 say, yeah, I'm in good health. I run, I do this, I do that. I'm going to get around to it. You're right. I do need a will, but I'll get to it. Why is that?
wills are like life insurance. People avoid discussing them because it's an acknowledgement that life is finite. So writing a will, some people in their minds, if they write the will, they put pen to paper, it means I'm gone. Just like with buying life insurance, some people don't want to buy life insurance because it indicates to them that there is an end coming. And so they avoid the topic. But the most liberating thing in the world is when you have a life insurance policy, then you've designated who's going to get what, and you have peace of mind because you resolved that conflict. Right. The good thing about a will is it eliminates family fighting if the will is done properly. Mm-hmm. You can eliminate all conflicts within the family that may arise because Susie wants the brooch that Jill's already been promised by Grandma. Well, you can eliminate that. Grandma promised it to Jill. It's in the will. That's it. Who are they going to fight with? You're dead.
That's true. That's true.
There's no fighting with me anymore.
Yeah.
So you can eliminate, put your mind at ease by putting these things to paper. And you don't have to show the will to anyone who's going to be an heir at the time. Mm-hmm. But you want to make sure your personal representative or the person you're designating as your personal representative knows that there's a will and where to find it. Because the last thing you want is to have a will that designates everything that you want to do for your wishes, but nobody knows where to find it.
Yeah, that's an important point. How can our viewers get in touch with you?
Well, my office is located on Georgia Avenue in Washington, D.C. My email is haleyfirm@gmail.com. My office phone number is 202-810-6329. And we're located at 7600 Georgia Avenue, Suite 405, Northwest.
Good, very good. I'm going to go again, this classroom thing, maybe it's me that needs all this knowledge, but I got a few more around questions that I want you to ask.
Sure.
And we have about 3.5 minutes or so left. Because I think these are basic terms that everybody should know a little bit about.
Sure.
Advanced directives.
Advanced directives are, for the lack of a better word, it tells in advance what people want in terms of how their medical treatment should be. For example, if in the event that you need to be put on a ventilator, do you want to be intubated? And how long do you want to be intubated? Do you want emergency life-saving measures done to keep you alive as long as possible? Mm-hmm. Or do you want them to allow death and life to take its natural steps and no additional extreme measures to be taken? Do you want emergency surgery or not? Do you want to donate your organs or not? These are all things that can be put into an advanced directive that gives the medical professionals your guidance in terms of how they should treat you as your illness or injury progresses.
Personal representation.
Well, I think you mean personal representatives. Personal representative is who you designate to personally handle your estate upon your demise. So in a will, you'll designate a personal representative who is to be commonly referred to as the PR, who petitions the court for an order to allow them to operate and do things as your wishes were. The PR is the person who does that. Successor personal representatives, for example, is in the event that a PR is unable or unwilling or is unable to continue performing as a personal representative, then a successor PR is who you designate to stand in the shoes of the first PR to carry out your wishes. Okay. If you don't designate a successor PR, then the family has to come up with one, and then that person has to petition.
Okay. See if you can take these two in the same context. Beneficiaries and contingency beneficiaries. Is there a difference between?
Similar to the personal representative and the successor, the main beneficiaries, these are the people that I want to take my assets. I want, for example, say I want you to have the balance of my bank account. But in the event that you are unavailable, or you can't be located, can't be found, or if you're no longer with us, then the contingent beneficiary takes it in lieu of you. So often there'll be heirs like, oh, I designate grandma to get this house. But if grandma is older than you and grandma passed away before you, then the contingent beneficiary is X. No, it's not grandma's sister, it's not grandma's child, it's Aunt Susie, because Aunt Susie on my father's side of the house, I want to have it in the event that grandma can't get it. You avoid the problem of, well, it was grandma's, so now it's mine.
It's mine.
No,
yeah.
you have a contingent beneficiary, so that if grandma's not available, it goes to the next person.
Well, let's see. We are almost out of time, but I want you to have the last word. What would you say to folks who think that they have some time I keep going over this because I hear it so much, where people just, they pass away and they don't have a will, and it's just a mess.
Short and simple, I recommend everyone have a will. If you are over the age of 18 and you can legally enter into a contract, then you have a contractual right that may be conveyed to someone else. And if you don't designate who gets those rights, who gets them? The last thing you want to do is not have a will and have no designated beneficiary, and the state keeps your asset because you didn't have a designated beneficiary and you had no heirs. So who gets your things? The best way to look at this is, you worked your life to earn things that you wanted. Now that you have them, who do you want to keep them alive for you?
Right. That's a good way to end. Howard, thank you so much for coming today. I know you have a lot. I know you're on your way out of town, and you're just trying to keep everything together. And so I thank you very much for spending some time with us today. You're welcome back anytime.
Oh, thank you for having me. It's been a pleasure. Thank you.
Thank you for watching Rock Your Block with our special guest, attorney Howard Haley, principal of the Haley firm, PC. If you need legal advice or have questions about today's show, Attorney Haley's information is scrolling on your television screen right now. Tune in next week for another great show. I am your host and producer, Tia Young. Be safe, and I will see you next week on Rock Your Block. Bye.